We have a simple opinion based on a very simple syllogism. Money is speech. Speech is good. Regulating corporate expenditures, therefore, is a form of censorship, and censorship is bad. But of course, money isn't speech. Corporations spending money is not a form of political activity that has with it some kind of God-given right. There is no personal freedom at stake here except for the personal freedoms of the rest of us who are not organizations but actually human beings. Once again, the Supreme Court is using the powerful ideologies and the simplistic syllogistic reasoning of laissez-faire ideology to mask an extraordinary act of force in the cause of immorality. Once again, we stand at the edge of an economic precipice. And once again, the core problem is that the government has been captured by economic elites that are successfully persuading it to allow them to use their existing market power to create more market power still. It's a self-sustaining, exactly how to say it. It's a self-sustaining process in which money breeds money. The money that is bred then uses economic power to buy political power, which then brings us back to the same cycle. Citizens United threatens the system. It grants free speech rights to corporations without regard for the internal rules of corporate governance, which mandate, as a matter of law, that corporations use their resources to pursue corporate interests, not national interests. In effect, the Supreme Court has invented, with no basis in the text, history, or structure of the Constitution, and only by stretching already perverse precedents to new excess, a permanent lobbying force for political corruption. Publicly traded corporations are neither citizens nor associations of citizens. They are highly structured organizations designed, rather successfully, to pursue profit with minimum internal constraint or dissent. If we give these organizations the right to intervene in the processes that determine the constraints, that determine the rules under which they play, they will simply lobby and electioneer to change the rules in order to provide more profit to themselves.
To me, this case really is going to stand for an increased sort of overriding emphasis on the special importance of political speech, speech about the political process, and the freedom to engage in political speech. I think this, to me, will be what this case stands for, a sort of reinvigoration of the First Amendment as its primary purpose as protecting political speech. And so this sort of independent, not contributions or lobbying precisely, but literally just saying this is what we believe, is something that was banned under the current law. And that was why I think the majority stuck its focus at. They said, that's odd. How could it be legal for the federal government, for Congress, to ban speech about politics, to prevent you from being able to speak about politics? And I think that, especially the core of it, which was don't vote for this person for president, was really not, they didn't break new ground by saying corporations have certain constitutional rights. Corporations have been able to exert constitutional rights in a variety of contexts, especially, for instance, in the context of if your property is taken or economic rights, but in other contexts as well. So this wasn't even the biggest difference. The difference is to what extent whether or not the government is less or more constrained when they regulate corporations, right? So it's not so much whether they have rights, but whether or not they have the same rights as natural persons. And here again, I'm willing to think that the court here was not so much interested in saying, well, corporations are special, important. It was not so much on the corporate identity, but they were focused on the fact that corporations do engage in speech, and that the people who run corporations do engage in speech in terms of politics. And that's really what was the core. Neither the dissent nor the majority argue that corporations should have no rights. In fact, really what I think the dissent and the majority are really disagreeing about is to the extent to which they think the government had a good reason to restrict those rights. I think that the dissent would concede corporations have some protection, but that their protection is very limited. They don't really need the right to be able to make independent expenditures about political candidates to be able to express their views, and the majority took a really much more absolutist view of the First Amendment. Right? To the extent you're going to do anything to restrict any kind of speech, you must convince the court you have a really overwhelmingly compelling reason. And they don't buy the rationale that the government offered, which was that if you don't allow a restriction on corporate spending, will distort the political process.
And this case is about something much more raw and much less nuanced than most legal questions that we address in law school. It is a tectonic shift, a power shift in American politics. This case is as much Machiavelli as it is Marshall. And that's true prospectively, whether you agree with the decision and like it or not. And if you believe that the problems in our political system, whether in Washington, D.C., or Washington State, or Wisconsin, or West Virginia, or Wantagh, are that corporations have too little influence in the political process and that the average citizen has too much influence, then Citizens United is a great victory for the oppressed. So looking at Citizens United through a lens of jurisprudence, this case tells us as much about the current court as it does about any particular doctrine. And whether one thinks of judicial minimalism in terms of constitutional avoidance, in terms of stare decisis, in terms of deference on political questions to the political branches, or, and this is critical considering the topsy-turvy nature of the decision, in terms of respecting the states in a system of federalism, I assert that Citizens United fails every single one of those tests. This case was not ever, and is not now, about corporations being prevented in any way whatsoever from having First Amendment rights. They had them before, they have them after. It's about the source of the money. And simplification can lead to inaccuracies. Start with the reality that the notion of corporate personhood is a creation of the state. It serves valuable purposes, and among them is the attachment of certain rights that are consistent with those of personhood. But it's not an all or nothing proposition. It's a sliding scale, not an on-off switch. In fact, proponents of this decision don't really see any off at all. There's a legal cliche that some of you have encountered in law school that in order to take advantage of certain benefits, the benefits of certain principles, you must also accept the downside of that same principle. According to the phrase, you must accept the bitter with the sweet. Well, if you catch yourself thinking that this was a victory for freedom, ask yourself whether the same combination of sweet and bitter that applies to you applies to corporations.
I believe the decision is undeniably a step forward for liberty. After all, it expands upon the reach of the First Amendment. But I also believe the decision is most likely a step backward for democracy, because I think it's inevitable that we'll find a greater number of our elected officials beholden to corporate and union interests as a result of the decision. Forced to weigh in on one side or the other, I begrudgingly side with the majority. To me, the majority's holding represents the lesser of two evils, namely the evils of increased government power and censorship versus the evils of special interest influence peddling. So the question to me is, do the shareholders need protection here? And if so, what protection should that be? What form should it take? Put constitutionally, I suppose, the question is whether there's a compelling government interest for federal intervention here, and whether the proposed solution is narrowly tailored. I question whether shareholders need protection here. The management of a corporation is overseen by its board of directors. Shareholders elect these directors. Shareholders entrust these directors to making decisions within the best interests of the corporation. Just as war is politics by other means, I'd say that for corporations, politics is business by other means. The same way, a corporation may choose to manufacture its products in China, or pay its workers a certain salary, or install red rather than yellow curtains in the offices. The corporation may choose to support or oppose certain political candidates based upon their positions vis-a-vis the interests of concern to the corporation. This is arguably a business decision like any other. Citizens United may help clarify both in a positive direction. Because Citizens United stands for the proposition that business corporations are not inherently suspect entities. They are not expected to act in such a subhuman fashion as to justify stripping from them free speech rights of the First Amendment. Their participation in our nation's political process is now welcomed because they generally have something of value to add to the public discourse. Had Citizens United come out the other way, it could have very well tipped the balance against a more socially responsible corporate world, cementing Michael Moore's vision of the corporation and its mind in both directors and jurists. So in short, I think that by treating corporations like citizens, the Supreme Court may have unwittingly encouraged business corporations to act more like citizens. And that would be a good thing. Thank you.